Okay, good morning, Europe, and good afternoon, Asia. Welcome to our webinar entitled Expanding Your Business Abroad and How to Commercialize Your IP Internationally. This webinar is brought to you by the International IP SME Helpdesk. Just a quick reminder, we cover China, Southeast Asia, Latin America, and India. Today's webinar will be moderated by myself. I'm project manager for Southeast Asia IP SME Helpdesk, and my colleague Benoit Tardy, IP business advisor of the Southeast Asia IP SME Helpdesk, and Benoit will be joining us for the Q&A session. So let me introduce you to our outstanding speakers today. Sorry, before we quickly just check on the housekeeping rules. So yes, the most important is that you can type in any questions you have throughout the webinar, and we will be answering your questions during the Q&A. So please stay with us. If you experience any technical difficulties, you can also send a message in the chat box so we can assist you. And today's webinar is recorded, so you will be also check our recording on the website in the next couple of days. So now let's move to the speakers. So our highlight speaker today is Elio de Tullio, as external expert of the International IP SME Helpdesk. From the China IP SME Helpdesk, joining us Matthias Zubimendi, IP Business Advisor. And from India, we have Girish Nagrai with us. And from Latin America Helpdesk, Cesar Elvira. Okay. And then we can have a look at the agenda. We have a packed agenda for today. So, well, I will give you a very short overview of what the IP SME Helpdesk are doing all around the world. Then Elio will give you an interesting presentation on IP commercialization when going international and how you can implement an IP commercialization strategy with some insights on the different regions. And then we will have some further tips from the IP business advisor from the International IP SME Helpdesk and some case studies. And then we will wrap up with the Q&A session. And then what we do as International IP SME Helpdesk. So our goal is to support European SMEs to protect their intellectual property rights when going to China, Southeast Asia, India, or Latin America. So you can contact us through our helpline service to receive an advice within 3 working days. We organize trainings and events throughout the year. Well, since 2020, it's mainly online, but we hope to be able to organize some physical events soon in the different regions and also in Europe. We have a new website, so you may want to check it out with some interesting articles, materials, publications. So let's go now. So I would like to give the floor to Elio, not to take further time from you, and explore a little bit more on why we are talking about IP commercialization today. So you will be able to share your screen now, Elio.
So can you see my screen? Okay. I cannot hear you.
You cannot hear me?
Okay. Okay. Now
okay.
perfect. Okay. Thank you.
Okay, good.
So just a moment. I try to fix the camera. Just a moment, because I don't manage to hide the. Okay. So the topic of commercialization of intellectual property is strictly connected with the possibility of expanding intellectual property rights and exporting products internationally. So my name is Elio De Tullio. I'm an Italian lawyer. I'm also a trademark attorney admitted to the Italian bar, and I'm the founder of De Tullio Partners. We are an IP boutique supporting Italian and European SMEs going internationally, and we follow all the steps of intellectual property monitoring, protection, registration, enforcement, and litigation. I'm one of the experts of the Southeast Asia and China IP SME Helpdesk, and I also support this desk in the training and webinar activities. So today we have a lot of topics to deal with. We will start with an introduction to IP commercialization, then a checklist, how to implement the strategy, case studies, and takeaway messages. So why IP commercialization is good for business? Well, first of all, because it's useless to keep IP locked in a drawer. Indeed, they are considered investments. So they are IP, they are assets in order to make money from them. So at the end of the day, the best possibility to internationalize your company, let's say with a remote control from your country of origin, is to protect and register your intellectual property rights worldwide, and then select partners, licensees, or other partners locally in order to make them use and produce products under your, let's say, authorization. So this is the main issue of intellectual property commercialization. So giving third parties the possibility to sell products using your trademarks, patents, designs, or other intellectual property rights. Why IP commercialization is good for business? Because it enhances the market value of your business. Once again, the king of commercialization is licensing. So the possibility to make third parties use intellectual property rights in the country of destination, paying, let's say, a remuneration for this authorized use. So IP is a way to increase the competitiveness in export markets, because once you have gained a good position in the country of destination, it's better to have tools in order to preserve this position and to disincentive third parties to do something similar to yours. IP rights also help you to differentiate your product in the marketplace and promote your products worldwide. So what a checklist for commercialization. I always have this. Okay. First of all, you need to carry out a market analysis. Another very interesting tool is the IP audit, and of course IP registration. That is a condition in order to start a good commercialization plan and strategy. To guarantee the success of IP commercialization, the market analysis can be carried out. This analysis can also be carried out using intellectual property database. There are a lot of firms specialized in preparing market strategies using intellectual property database, because you can get a lot of information from, for instance, patent database or trademark database or design database. And if you manage to match all these information, you can understand what are the plans of, for instance, your competitors, and what the market is going to ask in the next months or the next years, and what are the trends, the best trends in your specific sector. Market analysis is always a good way to understand your and your competitors' strengths and weaknesses and acquire solid ideas about potential scenarios of development of your products and services. Then another very interesting tool is the IP audit. So the way to understand what is the value of your intellectual property. It is something you should consider on a yearly basis because in order to understand what is the, for instance, the royalty rate you can ask in a specific sector, it is better to know what are the licensing agreements concluded in comparable sector or in comparable transactions. And so from this information, you can understand what is the best, let's say, the best royalty rate you can ask a licensee, or you can understand the value of your portfolio. So at the end of the day, an IP audit allows you to identify all intangible assets of your company, determine the overall value of your company, monitor compliance of your contractual obligation, because the perimeter of the intellectual property protection is also a way to determine the value of your portfolio, and also the possible interferences with your rights in the country, in the selected countries, or in the country of destination or of your technology. So an IP audit is very important in order to understand what is in your hands in terms of economic value, and what you can ask your licensees or your partners locally when you authorize the use of patents, trademarks, designs in these countries. The preliminary conditions, so the presumption of any kind of commercialization of IP rights and products IP based is registration. Of course, you can think about contracts based on non-registered rights, but they are very risky because you cannot guarantee the use in the country of destination, and in some countries there are also some statutory limitations. So let's say that intellectual property filing and registration, starting the process 1 or 2 years before going to the market is the best practice. Of course, in terms of the validity of these rights, it's very important to monitor in advance if these rights are valid in the country of destination or not. So for a trademark, it is better to carry out a trademark search assessing novelty and distinctive capacity. For a patent search assessing inventive step and novelty, and for a design, for instance, a design search assessing distinctive character and novelty again. You can use different routes in order to protect your IP rights locally. Generally speaking, the principle of territoriality is valid, so the protection is granted in the country in which the filing and registration process is started, but there are some exceptions, of course. For instance, the European Union is a regional protection and allows the protection of EU trademark and EU design. You can use also the international route. We will see the international route in shortly. These are the general duration of intellectual property right at the international level. So for a trademark, 10 years; for a patent, 20 years; for a design, 10 years, 5 years, until 25 years in European Union, and for a copyright, 50 or 70 years, depending on the country. In terms of the possibility to register your IP abroad, As mentioned before, you can follow the national route, the international route, according to the main international conventions in intellectual property rights. So the Madrid system for trademark, the Hague system for design, the Patent Cooperation Treaty for patents, or the regional route where existing. This section is related to trade secrets. The trade secrets are, let's say, complementary rights. Sometimes they cover know-how and all the part of your technology that cannot be protected through a patent because it doesn't achieve the minimum level of inventive step, and they are very important in the phase of negotiation with third parties, with licensees, with entities interested in acquiring your technology, and so entering with you into a technology transfer agreement. Not all information can be considered trade secrets. We will see that different jurisdictions have different ways to protect trade secrets, and this is the case in Southeast Asia, Latin America, China, and India. So your approach to trade secret protection must be a country-by-country approach and a case-by-case approach. But generally speaking, business information, strategic information, technical information, and financial information can be protected through trade secrets, provided that these information are not publicly available. They have a commercial value, and you know, the holder, adopted all measures, technical, technological, physical, and legal measures in order to keep these information and these data know-how secret. So it is very important in order to start the commercialization process to enter into agreements and to consider and carefully take care of IP clauses in contractual negotiations and contractual agreements. So let's say a preliminary phase is an NDA. So you can consider to negotiate and sign an NDA in order to oblige the other party to keep the information exchanged in the negotiation phase secret, and to prepare a good field, a good carpet in order to enter into your licensing or joint venture or technology transfer agreement. So the basic clauses of in terms of IP protection to consider for any IP any agreement, any commercialization agreement, are the specification about the type of information to be covered, of course the applicable and the applicable law and the competent jurisdiction, and everything is connected with the provision of damages in case of breach of contract. In terms of implementing an IP commercialization strategy, you can opt for different ways. One way is the licensing. Once again, the licensing is the king of commercialization. So it's a way to export your products, authorizing third party to use your invention, your sign, your design in the country of destination, and paying you royalties, so paying you some money to use these rights. So IP licensing is a process. It's a process whereby the holder of the IP grants permission to a third party to use his or her IP asset for a specific duration under certain conditions. Of course, if you are the licensor, you can exploit your rights at the best way. You can be remunerated for this use in the country of destination, and you can also use your network of licensees in order to expand the territorial coverage of your business. You can also agree with the licensee to improve the products or services object of the contract. So in this case, your licensee become a real partner of your business. These are this is the summary of some of the main contractual clauses to be considered in a licenses agreement. So declaration of warranties, so the precise identification and definition of IPR's licenses, and also the capacity of the licensor to guarantee that the use can be genuine and fair in the country of destination, the type of license, so exclusive, non-exclusive, and or sole license, depending on the number of entities authorized to use the right in the country of destination. Of course, the type of compensation that can be a flat fee or other kind of lump sum for the use of the sign or the invention, the duration, the right for the licensee to sub-license, the geographical scope, the rights on possible improvements, of course, clauses of confidentiality and applicable law and competent jurisdiction that are always under discussion during negotiation. There are other kind of commercialization of IP rights. For instance, technology transfer agreements. At the end of the day, the basis of these agreements are also can always be conducted to a license, so an authorization to use, or a franchise agreement where the whole concept composed by even the design or the package of your business is given to a third party according to the agreement that this concept cannot be amended and shall be used according to the franchisor instructions and specifications. The stronger way to control your IP rights and to oblige the third party to observe your, the requirements included in the contract in terms of IP rights is the licensing. Otherwise, you can also enter in different kind of negotiation and agreements. One of them is joint venture, when two parties decide to create a new and separate entity, establishing this entity according to a contract. And of course, they can also agree about the IP, the new IP generated by the joint venture, and different kind of percentage for all entities or all parties member of the joint venture. There are some advantages in entering into joint ventures agreements, so acquiring capitals to access specific technology, enhancing the capacity to source raw materials, capitalizing on local knowledge and network to foster acceptability. Of course, even in this case, do not forget to, in the phase of negotiation, to enter into a non-disclosure agreement and to carry out a proper due diligence in order to understand how your partner has behaved in the past, and what is the perimeter of its business, so you can rely on it when you start this new venture in a country of destination. General tips for IP commercialization strategy. Of course, register your IP rights. Be careful about contracts, and so be supported by your EU IP attorney that will also, let's say, use and cooperate with the local IP attorney for the operative and operative phases, and also for the representation before courts or before the local IP offices. Sign NDAs. Consider that in some countries, Southeast Asia, but also Latin America, some provisions can be considered unlawful. So a localization of contracts should be a priority in your plan, and include the confidentiality provisions in all employee contracts. There are some specificities about applicable laws in different areas. For instance, in Southeast Asia, be careful about non-competition clauses. They are generally acceptable, but you need to check if they are considered fair and reasonable according to the local law. Of course, think that the process for register IPRs in Southeast Asia can last some time, and be sure that you have enough time before starting the negotiation to have your IP registered, and also agree with the other party about the new IP generated after the signature of the agreement. The governing law, so the applicable law and the competent jurisdiction is always an issue. So try to be clear with your local partners and establish and include in the contract audit clauses in order to check the licensee's activities in order to avoid misappropriations or behaviors that go beyond the terms and conditions agreed in the contracts. Some other specificities regarding ASEAN countries and Latin America and China, of course. In China, well, China is a very complicated country. You need to be very careful about the recorder of licensing agreements. Depending on the IP right involved, you need to record the agreement before different authorities. And in some cases, there is a government control on some agreements. So this agreement shall be recorded, but shall also be authorized. I will skip this slide on technology transfer, but you will find it in the presentation that will be circulated after the webinar. As to Thailand, you need to consider that there is no legislation specifically regarding licensing or tech transfer. There are some general provisions of freedom of contract with limited interferences of the Thai courts, but be careful about clauses that are excessively restricting the rights of a party that can be considered invalid. And as to Brazil, there is the Brazilian industrial property law that presents general provisions on technology transfer agreements. There are some specific categories of agreement that involve transfer of technology included in this normative act number 135, with some specific provisions about licensing, about franchising, about technology transfer. You need to check locally if the rights can be correctly licensed or not. For instance, one case is related to unregistered intellectual property, where retroactive payments of royalties are not allowed, for instance. This is a peculiarity. In case of sub-license, the right of sub-licensing must be granted contractually, and because it cannot derive from statutory law. And be careful also about the joint ownership, because under certain conditions is forbidden. So I will now leave the floor to Matthias Zubimendi. Sorry if I was too fast, but there were a lot of material available afterwards.
Yes, thank you, Elio. So Matthias, would you like to share your screen?
Yes, can you see the screen?
Not yet.
Hello, can you hear me?
Yes.
Good. Perfect.
Okay, I will discuss with you some particularities of China that Elio briefly mentioned. When we talk about contracts, here it's very important to use the local language. It's going to be very efficient since local judges have issues sometimes dealing with foreign languages. You will be requested to present the translation, which in a case may cause an unnecessary problem, since your counterparty may present a different translation, and then you will be ended up discussing which party has right regarding the language, which is this simply can be avoided by signing a Chinese language contract. We normally advise also to choose as the local or of the applicable law, sorry, the local law using Chinese law. And also another typical aspect of China is when you're signing the contract, always check that the legal representative of the company is the one signing the contract and they are using the company seal. Here it's very common that companies sign directly with the seal. Regarding bureaucracy, as also Elliot mentioned in his presentation, it's very beneficial to register your license contracts. This will bring some tax benefits. This is very useful as well if you are trying to enforce it. Regarding licenses, there might be some governmental restrictions. There are some technologies that are prohibited to be licensed, sometimes are restricted, and some are for free. We will see this on the following slide. And if you are from a very specific industry, for example, pharmaceutical companies, I will advise you to, before entering the market, check what are the market access specifics, since for some industries they may require some very specific requirements that are very technical. Yeah, it's always advisable to check in advance, because you don't want to find something new once you are trying to enter in the local market. Regarding licensing, I want to also highlight that recently, the 1st of June, it came into effect the new patent law, which brought a new open license system in which companies that have the patent, either invention patent, design patent, or even utility models, they can open the technology in order to be open. This means that any company that wants to receive a license and they agree with the fee, they just simply by notifying and paying the fees, they can just start using and receiving a license. This also has another benefit, because those companies that open their technology, they open their patents, they will see discounts, or even they will be exempted for the annual payment for the patent. This can be done very easily, simply by a written statement presented with the CNIPA, the China National Intellectual Property Administration, and it can be withdrawn at any time. However, once you withdraw the open license, those licenses that were granted before, they will remain valid. And for concluding, regarding the restrictions that some technologies, some foreign companies can see on technologies, either for licensing or for owning, this is also important for research and development. If you companies planning to enter into a joint venture, take this into consideration. Here there are prohibited technologies, simply that foreigners companies cannot have access to them. Some of them are restricted. This means that you should get an authorization from the government. This authorization should be started by the Chinese party that wants to give you the license. And those technologies that are not prohibited or restricted are free of use. You can license them and own them. There is a list of those technologies, which is very long, very technical. So if you are planning to start a joint venture or receiving a license and you want to check if you are in one of these scenarios, don't hesitate on contacting the China IP SME Helpdesk. I give the floor to the following speaker.
Thank you very much, Matthias, for sharing the insights on China. Now let's look into India a little bit further. Girish? Cannot hear you, Girish.
Can you hear me now?
Yes, I can. Great.
Perfect. Good afternoon and good morning, everyone. I'll just speak briefly about India and the particularities about India. When we talk about India, one second. Just minimize it. When we talk about India, particularly with patents, there are three phases to it. A first phase would be before you file the patent application. The second phase during when the patent application has been filed, during processing of the patent, and then later on when the patent has been granted. So the first thing that you got to do is there is something you got to obtain a permission if you are a European company, but you have a subsidiary in India, and if you want to file a patent abroad, you need a permission from the Indian Patent Office. So this you got to keep in mind that you get this permission. And once you have filed the patent in India, you have to provide all the documents, furnish the details of the patent proceedings anywhere in the world. If you have filed a patent in Europe or US, the details of the patent application have to be furnished to the Indian Patent Office. And later on, once the patent has been granted, India has this requirement called Statement of Working. This is basically to check, this is basically for you to furnish that the patent that you have been granted has been worked in India. So there's something known as Form 27. You have to fill it and provide details about whether you have licensed your patent to a particular Indian company or the product has been in the Indian market. So this is just to make sure that the patent which the Indian state has granted is being worked in India. The second particularity that I would mention over here is in Europe, you have something known as secondary medical use patents. So if you already have a patent, but there is a new use found out of a particular drug, so you can patent it once again. In India, this is not granted. And with respect to computer implemented inventions, it should have technical character. It is a bit, Indian Patent Office doesn't grant CII inventions easily, but they do follow the law prescribed by even the EPO. So it's more in consonance. I would, coming with the fourth industrial revolution, we see that data is very important and trade secrets is growing in prominence. In India, we don't have any specific law for trade secrets. So trade secrets is kind of protected under the Competition Act, the Contract, and the Indian Penal Code. And as Elio had earlier mentioned, you have to make sure that you have certain measures you have implemented to protect your secret. And I would just, because there was a new rule passed out. So copyright softwares can be protected under copyright in India. We don't have any sui generis database protection in India. So with respect to copyrights, with respect to softwares, you have to furnish the first 10 pages and the last 10 pages of the source code. This would suffice to grant a copyright protection for the entire program. I'll just speak briefly about enforcement in India. There are a lot of cases, and we had a intellectual property appellate board which looked into revocation of patents and trademarks and stuff, but right now that has been abolished. It was not working efficiently. So you have to seek remedies from commercial courts and federal courts, but all the federal courts in India right now have they have started mediation chambers. So this is being encouraged a lot, so that this is under the auspices of the court itself. So you get relief sooner. And lastly, I would just speak about the Indian government schemes which are being provided to SMEs. Under Indian government started this special scheme for startups, which apparently enable very fast examination of patent. So within 12 to 18 months, you can get a patent granted if you are an SME, and there is a considerable fee reduction for SMEs, and this can be availed by European SMEs, Indian SMEs, by all SMEs. If you come under the category, then you have expedited examination and a considerable patent fee reduction. So with this, I hand over the floor to Cesar.
Thank you, Girish. So Cesar, if you can share some tips on Latin America, and I think also a case study is waiting for us on Peru, right?
There's plenty of content out there. You can bet so. But in the meantime, I want to check whether people out there is still awake or they're checking their mobile phones and their emails. You're not supposed to be that. And I want to ask you a question. Do you know the difference between a dog and a patent? Think about it. Let me know in the chat. In the meantime, I'm going to share my screen, of course. My screen has been sharing. Come on, let me know. Do you know the difference? Terrifying answers. Okay, I want to check this out.
Maybe the audience is a little bit shy.
A little bit. Or maybe this is the main reason why they're here, because they don't know the difference between the two of them. And this is really dramatic situation. Well, the dog is an animal, of course, the patent is an IP right. They have little in common, but they do have some stuff. For instance, if you take care of a patent and a dog, of course, they both can become your best friend, and it's not very recommendable to abandon them. And that being said, I hope you're all seeing the presentation, the slides of mine. And now we've all seen China, India, Thailand, and other countries of Southeast Asia. So I think it's time for Latin America. And here are the local aspects that I think you should bear in mind when you go into Latin America. Good question. What should I do? Well, here's the answer. Regarding any type of exploitation, and I want to jump right into the exploitations model that has been covered by Elio so brilliantly, no matter if it's a license or an assignment or a franchise. In Latin America, as in many other territories, you must register any agreement that affects an IP right before the national IP offices. If you want it to be enforceable against others, of course, the agreement will be valid anyway if you do so. But if you don't register, your local partner, for instance, or your licensee would not be able to take any legal actions for infringement in case they are, as he or she would not be considered as the right holder, for example, and this may hinder his position. What else? Well, all Latin American countries are members of the World Trade Organization. You can see it's, which stands for WTO. In addition, many of them have created commercial alliances, which are very interesting, regional integration initiatives, or even customs unions that facilitate trade between these countries. It is the example, Mercosur in Chile have a really good FTA. Other examples, well, the Andean Community of Nations, the Arabian Community, or the Central American Integration System, or the Pacific Alliances are good examples of what I just mentioned. These are international agreements that provide certain mechanisms that you can benefit from, like the priority right or the opposition right, and many others. So please use them. They are there for you to use them. But let's dive into the licenses because, as Elio mentioned, they are the jewel of the crown. And remember that he mentioned that it's really key to know the regulation. I hope so, because in Latin America, particular attention must be paid if the parties wish to include provisions that are new or different to the ones provided by law. So if you're not taking by default what is staying on the regulation, please take an eye on this. Give some examples. Uruguay, Brazil, Argentina, or Paraguay also, if the license is presumed to be non-exclusive, because you said, sorry, if you said nothing, the license is presumed to be considered as non-exclusive. So you must explicitly say, oh, this is exclusive license. Otherwise, they would take for granted that this is non-exclusive. So unless you state otherwise, it would be so. In Venezuela, a little bit sensitive country, right? But it is like it is. There are no higher legal restrictions because trademark licenses may only be transferred if the business is transferred as a whole. So you cannot separate trademark from business. They are a unite. On the other hand, in Brazil, the price for the use of a trademark where technology is not transferred should not exist 100% of the sales of the licensed products unless there is evidence to the contrary. However, the other Mercosur countries that I mentioned, let's say Uruguay, Paraguay, Argentina, or even Chile, do not have specific regulation in this regard. So you're kind of free in this sense. But when it comes to the duration of the license, which is real important nowadays, it is normally the same as the one of the IP right that they refer to. Ellie mentioned 10 years for a trademark, 20 years for a patent. You can hardly extend this because normally this exclusiveness that is provided by this intellectual property right is the basis for this license. Nevertheless, specific time limits may sometimes be set. It is the case for Paraguay, where exclusive licensing contracts may last for up to 5 years only, nothing else. And in the Andean countries, which means Bolivia, Peru, or Colombia, may establish time limits under this Andean Pact, as for example in Venezuela, that every IP right has a specific time limit stipulated by law. But we mentioned Venezuela is kind of different. Many companies have some concerns about the quality standards, and this is absolutely understandable. And the products manufactured and a license is normally what they take care about. So if that's your case, I'll tell you that in Paraguay, in order for a licensing contract that refers to a trademark to be registered, it must include provisions that enable the right holder to monitor the quality of the licensed product or services. In the Andean Pact countries, licensing countries must include regulations on quality standards too. And in Colombia, the holder of the trademark must effectively monitor the quality of the products or services and is responsible for any potential damage caused to third parties, which makes accountability really important. What happens in Argentina? Well, there are no regulations on quality standards regarding products manufactured under license. However, there are some rules that prohibit the use of clauses to regulate the commercialization, production, and technological development by the licensee. Joint use of the trademark by the licensor and the licensee, for instance, in Brazil, is also an issue because Brazilian legislation establishes that the license must expressly authorize the licensee in order to him/her to use his/her own trademark together with the licensor's trademark and advertising campaign. And finally, I would like to remark what happens when it comes to trademark registration, licensing registration again, because it is absolutely a must. Registration of the franchise agreement is not mandatory in Brazil, for example. And the sole requirement for its validity is that the contract is signed before two witnesses. That will be all. However, if the franchisor is based abroad, which is normally the case for European companies, and that may be you, of course, the agreement should be registered before the INPE, which is the National Intellectual Property Offices in Brazil, and notarized and legalized before the Brazilian consulate. So with that all in mind, we have a picture of all the aspects that are particular in Latin America and that you can take advantage, at least that you should bear in mind if you want to go and commercialize there safely. But I think that the best thing that I can do to illustrate how this operates in Latin America is really with an example. And here it comes. Nora already mentioned, it was a spoiler. Yes, we had a case study on exploiting your patent in Peru. And this was true story, okay? And we take in Braca, of course, this is not the real name of this company, which was an Slovenian SME in the agriculture sector. And they developed an innovative technology to protect crops from frost. The agriculture, the agri-food sector are really key in Latin America, and these green clean tech technologies applied to this sector are really important nowadays, okay? Now, in 1991, one of the affected farmers decided to create a method to control frosts more efficiently and economically. The resulting machine was inspired by hard frost that affected plantations during that year. So, you see, that with some disasters comes some inspiration, and it was the case. Now, years later, he obtained a patent and trademark protection in some European countries and the United States. Pretty normal so far, right? Now, right after, a Peruvian company, we're going to call it Pescol, offered to become his distributor in Spain in exchange for a royalty. And here came the problem. A year before the patent was due to expire, remember we mentioned something about duration of license subject to the duration of the intellectual property right? Well, a year before the patent was due to expire, the European entrepreneur detected that his licensee, this Peruvian company, was commercializing his machine in Peru without his permission. So what did the EU company do? Pretty simple. The Slovenian company contacted an IP lawyer, which is exactly what Elias said. If you have any problem, go find some, go seek some, go after a IP lawyer that is really good, preferably Euro-based, that can help you, but in any case, that has some experience in the ground in the destination countries. And this is what the Slovenian company did. And after a careful analysis, he informed that, first, his European patents did not provide him with any exclusive right in the Latin American country. Hence, no patent infringement was taking place. Wow, right in the chin. Second, the license agreement they signed was merely a template downloaded from the internet without any professional support. And this particular template didn't include any specific penalty clause. But it looked good though. So bad news, right? But, and I love plot twist, and here they come. The IP lawyer also noticed that the Piscal had been using this broadcast catalogs and other multimedia contents, these pictures, these videos, etc., in Peru without authorization, so addressing the Peruvian customers. So in the view of the above, the SME company was recommended to refrain from starting legal actions for patent infringement in Peru. There was no patent, so there was no infringement either. Second, it refrained from terminating the license agreement in order to avoid paying compensation or litigation costs. According to the license, nothing bad was happening. Third, attempt to renegotiate the license agreement for Europe amicably. Of course, there was a conflict, but maybe if they just take the nerves down, they can reach a solution. And finally, also send a CND, which means a cease and desist letter, to the licensee notifying that he will initiate legal actions for copyright infringement, which is really what they had, for using broadcast catalogs and other multimedia contents if the licensee refuses to reach a new agreement. Tough negotiation, they had to stuff 2 items in the pitch. Really good. Now, you may ask, and what happened there? What would you do in these cases? Well, in these cases, the outcome was really clear for this to be reached, and they signed a new agreement for Spain and for 3 additional European countries, not as non-exclusive, but as exclusive distributor of broadcast products for the next 5 years. Pretty good, right? And of course, the European company registered Bravke trademark in Peru so they can have a really safe operation scenario in the Latin American country. Really good, right? So what can we learn from this case? Pretty simple. First, seek IP professional advice prior to any commercialization and register your valuable intangible assets as intellectual property rights. This is pretty basic. Second, intellectual property rights are territorial rights. We already mentioned that. Therefore, you need to register in any country you aim to operate, at least in the short term, if you want to do that safely. Otherwise, you're absolutely naked, anyone can copy, you have nothing to claim, okay? Third, the use of templates when entering into agreements is tempting but dangerous. Elias said that you have to take care of this. This is what professionals are for. They have an eye on something that you don't. so the clinic eye can see some stuff that you may obviate. So sometimes this new tailor-made agreement is really more cost efficient to your case than something that's been downloadable. Of course, you pay for that, but at the end of the day, it's really a better choice. Now, besides intellectual property right registration, of course, there's good lessons in here. It is recommended to reinforce your protection by using contracts. Make sure to establish clear penalties, which is what they didn't, that operate in different ways in the event of an infringement. Of course, it is not of good taste to say that very savagely during the previous conversation, but at the end, you have to put that and be realistic. This is what lawyers are for, to foresee the most dangerous scenario and to put something that may prevent you from that, or at least that may reduce the risks that you're assuming. Also, remember that registration does not provide automatic protection. You need to be ready to monitor and enforce your rights. This is exactly what the Slovenian company did. It was monitoring the markets. It was monitoring what this licensee was doing, and this is the reason why they detected there was an infringement. Of course, it wasn't like that, but they detected the problem, and this is what a diligent licensor should do. Just two. And finally, the exploitation of any invention involves several intellectual property rights, which have different terms of duration and can be commercialized separately. You know, this technology had some patents, they had some trademark, and they had also some copyrights, all at the same time for a single machine. This may be your case too, on even more. So bear that in mind if you want to design your commercialization strategy, as it should be also in line with your intellectual property right strategy. And that will be all from my side, and I give back the floor to Nora.
Thank you very much, Cesar. So we still have a case study from Elio, but at the same time, we are running now a little bit late. So I wonder if Elio, I don't know, maybe we skip the case and we go directly to the wrap-up messages, because then we would still have time for a nice Q&A with all of you. How does it sound to you?
Perfect.
Okay, thank you. So you should be able to share the screen again.
Yes, well, just a few comments on the prepared case studies. So you can find this case study on the WIPO website. This is a Merlin that managed to export its technology worldwide, even through the patent application and registration worldwide. And they also managed to attract a lot of investments in terms of financial support for their research activity. And this is another case of a European company exporting products in Malaysia. So they started the cooperation with a local partner, and they managed to do that according to a good license agreement negotiated with the local partner. The IP lessons coming from these cases is always to use written agreements. Of course, as Cesar said, templates can be a good guide for you in order to understand terms and conditions of negotiation, but then you need to be assisted from an IP expert, preferably in European Union, that will liaise with the local IP attorney in order to have contracts and agreements tailor-made on your specific case. Of course, use NDAs before any kind of other agreements like licensing agreements. Check IP clauses and define the duration of IP licenses according to the duration also of your registered IP. Another way to preserve the risk that the agreements concluded with your local partner can be circumvented is to sign a kind of upgrade of an NDA that is an NNN agreement, so non-disclosure, non-use, non-circumvention. So in this case, the foreign party will also undertake written not to use or register IP rights that can be, let's say, similar to yours. and or in a competitive way with your company, and will undertake not to circumvent the agreement and not to interfere with your clients or your rights or with the price of the products at your disadvantage. In this case, as Matthias said, the agreements, in order to be enforceable in the local country, the country of destination, it will be submitted to the local law, and the competent jurisdiction will be the competent court of the country of destination, and of course some clauses regarding the amount of damages in case of breach of contract should be provided. So in this, according to this condition, this agreement can be enforceable in the country of destination, so against the partner that circumvented your the agreement with you. Even in this case, it is better to have the assistance of a EU IP attorney, so an attorney that knows your company very well, knows your processes, your needs, and your objectives, and that will liaise with the local attorney in the country of destination. So thank you for your assistance. I think that this is the final slide, so I will leave the floor to Nora.
Yes, thank you very much, Elio. I think we finally made it on time, so thank you for all speakers. And now we would like to invite all of you who were speaking today to stay with us for a few more minutes to discuss some interesting questions, and this will be handled by Benoit. So Benoit, I give the floor to you. And yeah, sorry, one comment. We put two guides on the slide because these two guides were developed by the International IP SME Helpdesk on the Patent Cooperation Treaty, PCT, and one on the Madrid system. The Madrid system, our drafter was Elio. So please feel free to download from our website. These publications are super useful, so don't hesitate to check it out. You have the links, so you can find them. Benoit.
Okay, yes. So thank you very much for the presentation from everyone. It was very insightful. We did receive some questions. So I have one which is for Elio. Well, basically you covered it during your presentation. It's my question is for Mr. De Tullio. What were the three types for international IP protection? So I guess we are here referring to the three treaties, but if you want to share some very brief comments on this.
Yes, well, the three, let's say, the three ways could be considered in terms of type of protection. So you can have the international registration according to international conventions for patents, trademarks, designs, and also the other IP rights. You have the local path, so local filing. For instance, you would like to protect your trademark in China or in Malaysia, you can file the application before the Malaysian Trademark Office or the Chinese, the CNIPA, the Chinese National Intellectual Property Administration, or you can select a regional path. The regional path, of course, it's not available in these countries, the countries covered in this presentation, but for instance, you have a regional path in European Union with the EU trademark and the EU design. There are, notwithstanding, there are some regional, let's say, privileges accorded, for instance, for the patent examination. For instance, there is a patent examination cooperation between ASEAN countries. So in case you have received a patent examination in one country and you use this route, you can also, you know, be your patent can be examined in the other countries, considering the first examination received in the first country. So you have to check these opportunities with your patent attorney, with your trademark attorney, because there are some privileges and some opportunities even at regional level, even if there is no a specific regional path in the country under examination today. Okay, thank you. It was mentioned in Matthias' presentation, the need of local translation, but now I'm addressing to Cesar. Any need of specific translation in Spanish or Portuguese
Is it mandatory for recording a license?
Every documentation normally should be on the language of the country. Now, particular attention should be paid to Brazil because normally it's not enough to have a Portuguese version of the documents, but an official translation, Brazilian Portuguese version of it, which is really, really specific. So if you don't have this specific translation, they may reject it. Otherwise, for the rest, Spanish and the rest of the countries, no matter what the source is, even Google translation, I don't know, would suffice.
Okay, thank you. Now I think we have a question for Matthias in China. So is it mandatory to record a license before the IP office? Could you share the risks of not recording a license?
No, it's not mandatory in the sense of you can license your right without registering with the CNIPA. However, doing so will may cause you problems when you try to enforce it, and also because it has some tax benefits, most of the companies here they decide to directly register the agreement.
Okay, and one question for different Girish in India. Is there any specific mandatory limits, let's say geographical or duration, to insert in the license before the Indian IP office?
Hello, yeah. There are no any geographical limitations per se, and the language is English. With duration, it's similar to what Cesar alluded earlier, that it should not be over the period of the patent duration. If the patent is granted for 20 years or the trademark for 10 years, it's the standard followed. For copyrights, it's 60 years. So the license should not be over the granted period of right.
So among the clauses we saw, you have no specific, let's say, regional input. Like we saw the 9 clauses from Elio. Basically, no, it's duration and yeah.
Yeah.
Okay.
No
we also, sorry?
No specific regional requirements. So yeah, and English is the language. So we have a lot of languages. So English is the language which is considered everywhere.
And which is accepted and valid before the Indian IP office.
Yes.
Okay. Last question, maybe for Elio. We have, which are the main instruments recommendation for market analysis? I think you can go briefly on this, as we already shared in your presentation.
Yes, well, of course, you can carry out a feasibility study. You can be supported by companies dealing specifically with market analysis. But once again, a very useful market analysis can be carried out also using patent, trademark, design database, and cross-checking, cross-matching the information together with some other information collected together with local partners. So this is a very good way to understand how companies are doing, what are they doing internationally. Of course, there is the limitation of the publication, because as you know, patents are secret until 18 months, unless it is not differently agreed. So this is the only limitation. But apart from that, you can cross-check information, and the patent database, for instance, as PassNet, the patent engine, search engine of EPO, or other free database at international level, patent scope of WIPO, can help you a lot in order to understand how what companies are doing internationally. Of course, you need the support of an IP attorney to put information together and receive the good output in terms of market analysis.
Okay, thank you. I see that we are almost running out of time. Indeed, IP commercialization, it's a really important topic and very interesting. We could still be discussing a lot more, but I guess we have to go to the end of this webinar. And do not hesitate if you have any specific question. All the experts are available by email. And now I will just leave the floor back to Nora.
Yes, thank you very much, Benoit, and thank you for all your speakers today for staying with us and giving more insights on IP commercialization. So we have this webinar recorded, so we will publish that and send it to all attendees, and actually also those who signed up but for any reason could not join the webinar today. And in our follow-up email, we will also include the email address of the China, Latin America, India, and Southeast Asia IP SME Helpdesk. So if you have any specific questions on those regions, you are very welcome to reach out to the respective Helpdesk to receive more insights. And with that, I wish you a nice afternoon or enjoy your lunch soon, and hope you will join us for our next webinars as well. And once again, a big thank you for the speakers today. Thank you very much, and goodbye.
Thank you.
Thank you. Bye-bye.
Goodbye.
Yeah. Bye.